Good afternoon. This is Drayson Boyd of AMCOMP. I am the Member Services and Certification Manager. Would like to welcome you to our second Workers' Comp update of 2022. We will present a webinar 3 times a year, and they're free for all of our AMCOMP members. Most of these webinars will focus on federal and state legislative updates. Before we get started, I wanted to review a few of the housekeeping items. Please take notice that we do operate under the antitrust policy. It's available for reference here on the slides. The antitrust policy will guide this conversation, and we ask that you adhere to it when submitting questions to our presenter. Throughout the presentation, feel free to submit any questions that you might have. Simply submit it through the question feature on your GoToWebinar control tab located on the right side of your screen there. Our presenter will answer as many questions as possible at the end. I'd like to introduce our presenter once again, Andrew Pauly. Andrew serves as the Public Policy Counsel for NAMIC in a cross-functional role supporting the state, federal, and international regulatory divisions of the Government Affairs Department. Andrew additionally works with the Workers' Compensation Council, Amicus Working Group, NAIC Working Group, and Policy Research Council. He covers civil justice reform issues and other international and regulatory concerns, among other issues. He joined NAMIC in 2018. He also obtained his WCP designation in 2021. Prior to NAMIC, Andrew directly participated in several insurance initiatives, including the privatization of the state workers' compensation monopolistic system and residual claim runoff, medical malpractice insurance reform, and third-party unfair trade practice reform. Andrew has extensive experience in insurance defense, including defending large commercial claims and coverage issues. So with that, thanks for joining us today. Andrew, I will give it over to you.
Thanks, Drayson. Appreciate that introduction, and welcome to everyone again. Thanks for joining us today to have a discussion about workers' compensation update. Let me see if this is working. Yep, okay. As Drayson mentioned, I am Public Policy Counsel with the National Association of Mutual Insurance Companies. We're one of the largest property and casualty insurance trade groups in the country, with over actually 1,500 members now, and 7 of the top 10 property casualty insurers in the United States. A way of overview, kind of, if you've seen the previous ones I've done, I try to touch a little bit on several gamuts, including if there's anything going on in the international space that might affect commercial insurers, workers' compensation insurers in the States. A lot of federal activity, especially since the Biden administration has come into office, a number of strong initiatives that have been put forward by Biden administration to talk about. We have some issues to talk about in the states, although the vast majority, a lot of the state legislatures are out of session now, unless they're doing a special session. And while there is always a few bills that may give heartburn, it appears that there wasn't significant trends at this point. There's always anomalies that caused a great deal of consternation, although we continue to look at public policy initiatives across the board, especially as it deals with workers' compensation issues, and we'll try to discuss some of those with you today. So on an international front, I probably brought this up in a previous presentation, but I want to talk just a little bit more about this kind of issue of supervisory technology. I think it's something that's an emerging issue. It's on the map. If it's not on your radar and you deal with an insurer or you're a stakeholder in the matter, it should be, because I think it's something that is globally increasing, and I'll talk about in the States here in just a moment. So the Global Federation of Insurance Associations is a association of insurance associations. So I think their premium with all the members involved is probably something like 90% plus of the global premium their members write. This includes the United States, the trades in the United States, the trades all across Europe and various countries. In fact, just until recently, Russia Federation had an insurers association, and they were actually removed by JAFIA based on the war that they're or the conflict that they're pursuing against the Ukraine. So that's kind of gives you a little flavor of there's a total international look on these issues. And one of their working groups is an insurance disruption working group that has focused on emerging regulatory concerns. And one of those is supervisory technology. So we hear a lot about InsurTech, right? And folks that are innovating the business, the business of insurance for to bring wonderful products to consumers and create a better consumer experience through technology. Some of these are startup companies. Some of these are partners with existing incumbent insurers, and some of these are already incumbent insurers that are coming up with new innovations that are changing insurance as we know it. But concomitant with that is the fact that we have regulators now saying, look, you're using predictive analytics, you're using artificial intelligence, you're using machine learning. Maybe we should be doing that and regulating the industry. And so JAFIA has come out with sort of like a white paper on supervisory tech that kind of has some talking points. You can Google this or search it. It's you can find it on the web. But some of the points that they talk about that's important, I think, are, first of all, industry and regulators should seek out dialogue before something like this happens, before the regulator actually uses technology to predictive analytics, if you will, against the industry in order to predict some sort of regulatory compliance issue or what have you, and to seek out what is being sought by the regulator. Additionally, there needs to be clear and achievable objectives. Data should not be accumulated just for its sake, nor should the use of technology just be used for the sake of technology. It should provide positive outcomes for the regulators, for industry, for everyone that's involved in the matter. And again, another thing that's being looked at is the regulatory burden. I'll talk a little bit here in a minute about the MISTIF paper and NSC, but this is supposed to heighten the regulatory experience, possibly reduce redundancies and other concerns. It should not increase problems such as significant false positives that have to continue to be run down, and which takes up human capital, takes up costs for regulators and for the industry and all the stakeholders involved, a lot of waste of time. There's also concerns about data protection, confidentiality, cybersecurity. I think we all understand that data is only as safe as the weakest link, right? And some folks, such as here in the States, are stronger on protecting confidential data when you're dealing with regulators. Some have more funds and more robust systems, and so you have to take a look at that. There was some discussion in the paper about role confusion and potential abuses. That is, once the regulator is getting the data, potentially granular data, transactional data, might there be an intervention of sorts that's telling the company how to run their company? and that might be taking it pretty far asunder, but their concern is there enough to include it in the paper. And then again, we don't like things necessarily being jumped to conclusions. There should be a continuum of response based on the level of concern and those kind of issues. Usually least invasive to more invasive as there appears to be a problem through analysis. There's always can be exigent circumstances or situations where regulators maybe have to move a little more quickly than others. But for the most part, it should be measured in response. So this isn't really all science fiction. This is actually going on here in the United States. The NAIC, the National Association of Insurance Commissioners, there's a MISTIF, it's a task force, Market Information Systems Task Force. It actually is attempting to, working on adopting a paper. For the last 2 meetings, it has failed to adopt it because of significant lack of consensus in this area and the concerns that we've kind of talked about here. But what they want to do in the paper, there's kind of 5 different parts, but they want to survey, this is in the United States now, they want to survey currently available market analysis data and identify substantive deficiencies, including consistent reporting of data. They want to adopt a more rigorous statistical approach to identify predictive power of market scoring systems. So again, this is kind of the, they want to use predictive analytics to potentially predict regulatory concerns and compliance issues before they occur. So there's been movies about this, but we're at this point now. Incorporate promising AI models of analysis. And again, additionally, they want to increase their qualitative analysis by looking at larger volumes of textual evidence, such as complaint data. So you have unstructured data, as we all know, handwritten words, complaint data that anyone can file with a regulator across the United States. And the regulator is usually bound to take a look at that and decide if it's got merit and pursue it or not, if there's a complaint against an insurance company. And so they want to use the ability to, discern patterns of this unstructured data that might be filed with regulators. And then systematically explore, more larger data sets. So we hear about big data, we hear about use of big data, and we hear about transactional data because for the most part, depending on the situation, regulators in the states usually may do data calls if they're concerned about a particular issue, and maybe it's more at a summary level. This is talking about getting transactional data, very granular transactional data, and using it, which is almost sort of like a real-time, could be potential for like a real-time market conduct exam, on an ongoing basis. So there's a lot to unpack here and understand, but I think it's something that everyone needs to understand because some of the concerns that have been exhibited regarding this has been include that it's premature. You have the NAIC and various regulators and for that matter, global regulators looking at the use of AI and machine learning by industry and still coming up with regulatory tools and provisions for industry to comply with. So it seems like this kind of is putting the cart before the horse, which in turn may cause a lot of waste of effort, a lot of redoubling of effort, resources by the state and industry. It would subject highly sensitive proprietary data, transactional data, to cyber threats and confidentiality gaps. The paper itself even talks about, the NAIC MISTIF paper even talks about potentials for false positives could subsume and take up analyst time, running those down all day long when the market's not being regulated. And there hasn't been determined at this point that for at least in the United States under the NIC, that there is a superior predictive analytic product out there that's going to more efficiently regulate the industry than the current processes that they are involved in. So again, I don't think the pushback on this is so much that, you know, a regulator cannot get that data which they need to regulate the industry, especially when they have a significant concern, consumers are being harmed, et cetera, and so forth. So it's not about keeping information away from the regulator. I think it's more about how much do they need to do their job, and how quickly do they need to implement these systems to efficiently do their job under the current state laws they operate in, and any of the impactful federal laws. Moving on now to federal. Have a lot going on, obviously, in the federal realm. We continue to see Congress discuss and debate, including packages such as BBB, the Build Back Better spending package by President Biden, but that appears for all intents and purposes to be dead on arrival. There has not been the ability to garner the enough votes to move this along any further. We still monitor federal workers' comp oversight. We have the mask mandate that was rescinded, independent contractor status issue, inflationary trends, supply chains, and cannabis are some of the few I'll continue to discuss. So as we all know, anyone dealing with workers' compensation or the insurance industry recently, everyone seems to be very embroiled in discussing inflation. Inflations can have many impacts, as we all know, many concerns of its impact. You can see there that in April it rose 8.3%, highest level since January of '82. No question we're seeing, just as with COVID, the overused word, but the true word of unprecedented. We're seeing quite a bit here. We're seeing workforce shortages, the supply chain disruptions. And again, this affects different lines differently. We see, you know, the increased geopolitical events, as I mentioned, in Ukraine. And so there's a lot of issues there. We have the Federal Reserve acting, the largest increase since 2000. And then, you know, more specifically to compensation, I think we're seeing some, obviously, wage inflation. We're seeing medical inflation. Some folks might say, well, you know, wage inflation is not necessarily a bad thing for workers' comp, but I think the importance here, and we all know that it has to keep track with payroll, it has to keep track with premium, it has to keep track with indemnity benefits. So if that gets out of whack, that is, if one of those jumps a little higher than the other, it can cause issues. Same with medical inflation. As long as there's time to build it in to models, I think it's not as concerning. But I mean, any increase in cost is always a concern for anyone, obviously, because ultimately the policyholder is going to have to potentially pay more. No question that workers' compensation has seen many years of positive rate reductions and issues. But as these issues continue to pile up, rate and reserve adequacy is always something that is a concern to continue to watch. I'm sure everyone and any of your entities or anyone else is making a big, spending a lot of time discerning these issues. Then I think if you add to this mix something that you may hear about a lot, mainly in probably more the personal lines and commercial lines, is this discussion of social inflation and what does that mean. But when you add that to the mix, plus the inflation, obviously many concerns for industry. You know, there's many definitions of social inflation. I think a lot of it is just disproportionate, unwarranted increases in claims and litigation costs above a normal inflationary trend And sometimes it's just something that's untethered to economic reality. I mean, anyone measuring, for instance, damages, obviously you think yourself is worth, sometimes unlimited amounts of funds. And I think sometimes we see in the courts these issues, very large non-economic nuclear verdicts, which we hear about in the tens, hundreds of millions. In the other lines, we have third-party litigation funding that is we see from single plaintiffs litigating to massive hedge funds that are kind of speculating on the insurance market and the litigation market, and other factors. And it does appear when you continue to look at some of the issues that this concept is moving more into workers' compensation to the extent it hasn't already been there. We know about the expansive presumptions, and these are well beyond for instance, the first responders, moving, to entire workforces, um, and various entities. We see early claim involvement by attorneys. So this is not talking about that folks are not entitled to representation by attorneys. They are in any aspect, but it seems that early on, in some instances before claims experience is able to work, it's magic, as we know. You have an attorney involved, and many times you see attorney fees being taken for medical only claims and those kind of issues that really just exacerbate, does not really get the claimant much more or any more than if they just dealt with the insurance company directly and in their claim. And I'm not saying there aren't specialized claims and specific issues that need attorney involvement. It can be a complex situation, but sometimes there's no chance given to the claim process itself. Let it take its effect. We've seen retroactivity discussions in a number of issues. Also the extension of many of these issues for much longer periods of time that might have been acute or imminent concerns. We see exclusive remedy erosion. We see a lot of advertising, a lot of negative advertising against the industry that is really hard to rebut. I mean, it's not hard to rebut, but it's hard to combat the barrage of advertising and negativity without the industry looking as if they're just wanting to be argumentative. But the massive amounts of negative advertising, can take its toll. It can take its toll towards corporate America, towards corporations, towards businesses, and public opinion. And then, of course, we have workforce attitudes. We have demographics. We have modes. I saw the other day millennials, Gen Zers are, 4 billion plus in the world. I think the decisions are starting to factor in to decisions on across the board. They're probably the largest market right now for anyone to sell to, and they have different thoughts and different attitudes, as every generation does. And then, of course, we have the growth of the gig economies. We have folks that work different hours. We have the effects of COVID, and people that want to work from home now, don't want to go into the office place. So lots of changes there, but it really makes it for a difficult situation to operate in the environment with the inflation and social inflation, unless they're addressed somehow proactively. Just continue to bring up the federal oversight of workers' compensation, U.S. Department of Labor activity. This is according to them, these bullet points, their concerns with the current state-based regulatory system. They believe there's an ongoing and systematic decline in the adequacy of benefits provided to injured workers. They believe there's a massive cost shift to federal programs. And they would like the Office of Workers' Compensation Programs, OWCP, to monitor and move to basically create benchmarks for conduct within the states. This, again, is not over, is not, it's been discussed before, I'm sorry. It flows from the 1972 Commission on workers' compensation in the states. There was a 2016 report as well, where the U.S. Department of Labor was moving towards some sort of federal oversight or return to reporting and maybe suggestions to Congress, setting up the benchmarks, those kind of issues, sort of a federal preemption, if you will. So I think it's still a concern. It's not going away. It was in a spending package last year. That language was able to be removed in subsequent hearings. There was discussions by the Department of Labor that they felt like they still have the authority to do this. They would obviously like more funding to do it. And so I don't think they've stopped at this point. There continues to be a need to watch new fiscal year budgets, new spending plans to see how they may go about this. And there's also some thought that depending upon the elections, as we all know, that are going on now in the states, and we'll be going in the national election in the fall. If there's a change in Congress, and again, no one knows what will happen in a fall election, but if there was a change, that there would be this concept of a much more administrative overreach, if you will, by the administration, because if they can't get a bill through Congress, they've got to move through their administrative agencies. And again, most know that this has been an issue that the courts have been looking at for a period of time. And there is this concern, especially from the U.S. Supreme Court and many district courts, federal district courts, that Congress is kind of shirking its duty and not passing these laws. And if agencies are going to kind of usurp their authority, that's a concern. If you can't get a bill through Congress, then you might not have that authority. So something we'll continue to watch. Again, NCOIL, the National Conference of Insurance Legislators, came out with a resolution last year in regards to this, supporting state-based workers' compensation laws as an effective means of protecting workers. There's nuances, there are differences. I think that there's a strong argument that the differences in the states is what makes the workers' compensation system resilient. The state-based regulation, states know their industries, their workers, what is known best for them. Their legislatures know that local-based regulatory need. And it's not a one-size-fits-all, and there is a concern with the federal oversight that you're going to have, kind of a mandate that fits across all states that must be complied with, which could cause potentially excessive costs, unwarranted costs, and not really do anything more further for the worker. In fact, harm the worker and raise costs for employers who are going through a tough time from COVID anyway, to get through that. So this is something that is really still continues to be one of those things that I don't know that we want to put completely on the back burner yet, and won't be for the next couple of years till we see where the Biden administration wants to go with this in the Department of Labor. As mentioned, we also have the federal mask mandate court decision, 418. District Court in Florida found that the CDC exceeded its authority, and this is kind of regardless of how you feel about this particular situation, and I understand there's many people feel very strongly about mask mandates and not. This is going to be the kind of the arguments that are going to be set up down the road, at least for the next couple of years. That what authority do these administrative agencies have to do some of these issues with no laws from Congress? What is the extent of the authority of the executive office? Um, and the court did vacate the mask mandate. Mainly this involved travel, transportation. Anyone that's flown in the last couple of months understands that change. And the CDC basically was trying to use a Public Health Service Act that aimed at isolating, destroying diseases, but it leans more, at least in the decision, it leans more towards quarantining individuals, prohibiting the import of animals, etc. Sanitation was determined to be too broad a reason for implementing such a measure. But the Biden administration has said they would seek review to the 11th Circuit Court of Appeals. So this is not over. If it's appealed, we'll see what the 11th Circuit does, and then this could be one that goes to the Supreme Court for the final say, United States Supreme Court. And this comes on the heels of sort of the vaccination mandate as well being overturned, especially towards the employers of 100 or more individuals, termed to be sort of arbitrary number to pick out, and the process by which they went there as well. So again, it's something that I think you play out, you see how this plays out, but it does appear that at least the federal courts are getting more suspect of some of these federal agency activities, especially in these areas. But again, I think others would argue, well, these were exigent circumstances. There's concern out there. We're trying to protect the public. And I think the question just becomes, how far can you go to do that, to protect the public? How broad can you go? Do decisions need to be more narrowly tailored and so forth? And I think that's what has continued to play out in regard to these mandate status. Cannabis. So another several developments in cannabis. I think sometimes we probably feel like we can't get away from talking about cannabis. It's clearly been something that is moved across the country. There's a vast majority of states that have some sort of law, whether it's legalization or medical marijuana and cannabis usage, hemp usage, and the parameters we continue to ascertain. Recently, a couple of issues. There's been a Prepare Act introduced in Congress. There's a discussion and passage in the House of the MORE Act. There's a little discussion on Delta 8. And then there's actually a couple of cases at this U.S. Supreme Court right now, which are interesting, at least for the workers' compensation space. So the Prepare Act was introduced in this Congress. It would make the Attorney General establish a commission to study plausible and prompt pathway to cannabis regulation. It looks at impact of criminalization has had on the country, lack of access to financial services, research on the medical issue, training, crop guidance, cannabis hemp issues, barriers to federal legalization. So far, this has not really moved that much, not a surprise, but that doesn't mean it won't go somewhere as a exploratory tool in moving this along. Much more aggressive, though, is the Marijuana Opportunity Reinvestment and Expungement Act, the MORE Act. This was passed back in April in the House. It would deschedule cannabis, which a lot of folks are seeking. It would come up with a taxation plan. operational plans, and more importantly, it would do expungement of criminal offenses. So those that have been, convicted of marijuana-related offenses, possibly retroactively, obviously, would be eligible for expungement of criminal offenses. Um, I think the reason I mentioned this one because a lot of people understand that the Senate is pretty divided right now and not moving a lot of legislation like this. Um, there continues to be discussion, I mentioned it in the past, is the SAFE Act, the SAFE Act, which is a financial services and industry related bill that creates a hold harmless for insurers who operate in this space and deal with state approved cannabis industries. Um, and that's passed several times in the House, as I'm sure most on the call know, and in different vehicles. But it has not gotten any traction in the Senate, and mainly it's because of the huge divide in the Senate. Because interestingly, the Democrats, the progressives, don't feel it goes far enough. The SAFE Act, it gives too much to the industry, and the conservatives, the Republicans, feel that the bill may go too far in assisting the cannabis industry. So, what Majority Leader Schumer has mentioned is that if bills like the MORE Act could get passed, maybe he would move the SAFE Act as well. And so it seems like there's been this push over the last 30 to 60 days to come up with a package of bills that could get this through. Obviously, there is concern by some about the fall elections, and they would like to get something through potentially before the fall elections if possible. May not go anywhere, but it looks like that to get something like the SAFE Act through, which would potentially provide some protections from federal intrusion. There hasn't been, I'll talk more about that in a minute when I get to the Supreme Court cases, but there hasn't been any guidance from Merrick Garland, the Attorney General, on enforcement. And so it's interesting to see, where this would go, if anywhere, what it would mean. So we'll continue to watch that. I also just talk about Delta 8 synthetic THC, CBD. I don't know if folks study this very much, but there's been questions come up, concerns, some guidance from the FDA and the CDC about Delta 8. It apparently is a synthetic product, somewhat manufactured from hemp, and it still remains a Schedule 1 controlled substance. But there's been quality and safety issues. So the confusion came from there was a 2018 Farm Bill that legalized some hemp products, I think mainly for industrial hemp usages and concerns. So the folks that are making this Delta H synthetic argue that under that Farm Bill it's legal. Of course, other folks argue no, it's still a Schedule 1 controlled substance. There's been adverse events following consumption. The way this is made is potentially with unsafe products such as bleach. In fact, some sales pitches have been, we don't use bleach in our process. These can be in edibles and vaping products and other types of products that are provided. And there's a lot of harmful byproducts created by it. So I think the discussion here is, again, when we're legalizing cannabis usage, we've got workers out there using some of these products. What's the sequela from using a product that's been made with bleach that's going to cause significant harm to a person for their usage? Not all cannabis is the same. Not all hemp is the same. I believe there was a airline stewardess in California that was harmed, or I'm not sure, she may have expired, but was harmed quite a bit. There's lawsuits pending. There's been several lawsuits concerning the efficacy and safety of these products, and so it creates a real concern as to what's out there, what are workers consuming, and whether they're even legal products, and even if they are legal products, what they may be doing to their system on those issues. So something to ponder. And then lastly, on cannabis, I mentioned there are two United States Supreme Court writs of certiorari, which is a request for the Supreme Court. Of course, the Supreme Court does not have to take up cases from state courts. It's basically asking for permission for this, or asking the court permission to take up the case and decide it. And there's two cases. They're both out of Minnesota, the Bierbach case and the Musta case. And interestingly, the Minnesota Supreme Court ruled that the Controlled Substance Act preempts a workers' compensation court order mandating reimbursement for medical cannabis. So this is stuff that has been considered through the states. As we all know, there was a couple of decisions that went both ways. And we also had New Hampshire and New Jersey Supreme Court say that it doesn't preempt reimbursement. But I think one of the problems with the New Hampshire and the New Jersey court decisions was that a state Supreme Court, as we all know, cannot hold harmless an insurer from a federal investigation. So those decisions, while sort of forcing reimbursement or upholding reimbursement, is still creating a difficult choice for an insurance company in reimbursement because of these situations. And so when you go to the briefs, the parties, of course, the insurers are arguing that they should let the Minnesota cases stand. They shouldn't take, the Supreme Court should not take these cases up and decide them. But if they do, excuse me, Bierbach's the better case to take up, they believe, because it has a more diverse record that has been developed that can be looked at. And it's interesting to look at these briefs. You know, in this case, the claimant in the Bierbach case, he admitted, you know, that he had misused drugs and alcohol in the past. He admitted using marijuana throughout his life, but he also admitted that he, you know, his doctor had no control over the frequency or amount of medical cannabis that he receives, and no one monitors his use, because of course, as we know, because it's still a federal controlled substance, physicians cannot legally prescribe it, and they go to these medical dispensaries, obviously, to get them based on how boards or how states have set up their programs for medical marijuana. He also said that, you know, he his dispensary left his dosing decisions up to him. So he made the decision how much of the cannabis that he needed for his injury, and that he would use a lot more of it if he could afford it, you know, if he had the money for it. So he would use a lot more of it. So some interesting testimony in that case. Also more interesting, I think, is the fact that what I mentioned before, that we have not had any guidance from the current administration, Merrick Garland, U.S. Attorney General. And I think a lot of folks, just as the two Supreme Courts I mentioned, are saying, well, you know, the U.S., they're not going to do anything in this case. What are we worried about here? Well, interestingly, the United States Solicitor General filed amicus in these cases, both of these cases. The Supreme Court asked them to file. They did file, and they argued that it is still Schedule I controlled substance, that is still against the law. And they argue that the Supreme Court should not take up these cases, that they should let the lower court, the Minnesota Supreme Court decision stand, that the Controlled Substance Act did preempt the Workers' Compensation Court order mandating reimbursement for medical cannabis. So Interestingly, not only do you have the insurers arguing that it's preempted, and I think it's difficult for a Supreme Court to say that it's not preempted and have any effect on the legality, but then you have the United States now taking a formal position before the Supreme Court that it is an illegal Controlled Substance Act problem, and it does preempt any workers' compensation order requirements. So again, we'll see what the Supreme Court does with that. Continue to monitor it. Maybe we'll have a decision by the next time we get together. But interesting for folks following this issue. Additionally, there was another issue with there was a Trump administrative rule, Trump administration administrative rule dealing with independent contractors. Some felt the rule that the Trump administration filed leaned more towards finding independent contractor status for federal purposes, wage and hour and so forth, under Department of Labor rules. The Biden administration, as we know, came in and had concerns with that rule, attempted to withdraw it, and then provide their own rule concerning the same that many felt was more towards the ABC standard of presumption of employee status as opposed to independent contractor status. And the court there in the Eastern District of Texas felt like or decided that the Biden administration did not follow the rules in noticing and providing comments, and withdrew the changes to that independent contractor rule. So I think we're back possibly to the Trump administration rule, and obviously the Biden administration will probably engage in, they're back to square one, but they'll engage in rulemaking. So we have this kind of gray area until proper notice and proceedings are taken care of in that particular situation. Also, TRIA inquired of the industry concerning the terrorism risk insurance program. They're getting much more, I'd say, in depth in asking industry questions about the TRIA program. You have the points there that they were looking at: the overall effectiveness, the availability and affordability, and interestingly, any impact of the program on workers' compensation insurance is the last one. So definitely dealing, there were comments submitted. A report is due to Congress at the end of this month. And I just put in the material, I put in the PowerPoint, just some of the questions that they were seeking responses to. You can go on their website to possibly see some of the comments that were provided. Sometimes they make those available. I haven't had a chance to check at this point, but I think that, again, something to keep in the back of your thoughts concerning where, if anywhere, they're going to go with the terrorism risk insurance program, which was re-upped a couple of years ago for a period of time, longer period of time than usual. And we'll continue to watch that. Pretty esoteric here. I won't spend much time on this, but there is the ability of the U.S. Environmental Protection Agency to now, under the Toxic Controlled Substance Act, was enacted in 2016, ban certain substances, in this case, chrysotile asbestos, which is involved in diaphragms and sheets, gaskets, brake blocks, aftermarket parts. There was a 1991 court decision that did not allow them to do that. There were some changes to the Control Act. There's been real concerns about how this process was handled, since this will be the first one under the new Act, 2016. You had a lot of experts that were arguably testified only on behalf of plaintiffs, and I felt that there was not much balance in this process. And so we'll see how this first one goes, but then the intent is to move on to other chemicals. And of course, if you have something directly from the EPA banning a substance, it's going to increase claims, it's going to increase workers' compensation claims, it's going to increase lawsuits. And some may argue for the good, but the point is, still, it just seems that if the process has a concern, I think that's something that will probably have to play out as we continue to see these decisions in this area. All right, moving on. Let's see. There we go. Move over to state real quickly. Again, like I said, not a whole lot. I wanted to touch base here. We always see a lot of issues: climate risk disclosures, privacy legislation, cyber risk, ESG investing, sandboxes, erosion, exclusive remedy. I'm not talking about all of these now. I'm sure most of you hear about several of these, several times a day, all disconcerting, all things that need to be looked at, more so for potential redundancy in responses, regulatory burdens that are unnecessary, and those kind of concerns. I think, obviously not evading the concerns. Just an update on, we were talking about in the last one, the workers' comp exclusive remedy and take-home liability, and where spouses come home and possibly infect their spouse or other persons. Is that protected by the workers' compensation exclusive remedy system, or is it going to be into the court system? And this is by no means comprehensive. This is just some discussion cases for context, such as the one in Maryland where, and again, these can be appealed and there's changes, and that's kind of why I'm updating this. But that original case said there was no duty to an employee's spouse for contraction and potential spread, of COVID-19. Then you had the Kusiemba case, which I mentioned, and it said again that or claims against the employee because the spouse alleged exposure brought home, they alleged negligence and various concerns. And the court granted a motion to dismiss, the appellate court in California, and said the claims were barred by the exclusive remedy. However, this case has been certified now to the California Supreme Court, and it's anticipated, although no one knows for sure, that they may take it to possibly reverse this middle court decision, this appellate court decision, because as we discussed in the See's Candy case in California, similar situation, but the employee and the spouse both died from COVID-19. The employer filed a motion to dismiss based upon the plaintiff's claim of being barred by the exclusive remedy. And the court held no, that the suit was not barred by the exclusive remedy. It was not a derivative injury doctrine. This is what they were arguing, that any derivative injury from an original workers' compensation claim would be covered under the exclusive remedy. The court said no, that the suit was not barred by the exclusive remedy because it was not a derivative injury, that the spouse's contraction, even from her employer, her husband, or the employee, was not a derivative injury, but a new injury. And the Supreme Court of California denied review of that case, which makes that lower court the law. So again, it appears that that's going to be a change in those particular situations. And again, this is just indicative of some of the exclusive remedy erosion. Not saying it's happening everywhere, but it's something to be aware of. A lot of folks look to California and their precedent. So we'll see how it continues to play out in California. NAIC continues to work on a restructuring mechanisms. white paper, I think is something to be aware of. This comes from the UK Part 7 Transfers Act that basically allows you to move a book of business to another entity through novation. You don't have to pay. The contractual responsibility is transferred to someone else. That's not necessarily with the policyholder permission. You have to go through a very lengthy process of court approval, regulatory approval, independent expert approval. And there's several statutes. There's insurance business transaction statutes that I mentioned some of the states there. There's corporate division statutes that I mentioned there. There's an AMCOMP model. And there's a restructuring mechanism subgroup that's coming up with foundational principles and best practices. So this is about, there's guarantee fund protections. Their arguments, some of their arguments involve that, entities that go into these transactions, the policyholder, if they have guarantee fund protection, should not lose that protection in the transaction. And vice versa, if they didn't have it when they're transferred, they shouldn't gain it. So there'll probably be some model law amendments to guarantee fund acts across the country. And there's also issues of how to deal, for instance, with companies that are created just to run off, for instance, a book of business and that kind of situation. So they're doing through that, something to be aware of. We mentioned independent contractor status with the Biden rule and the Trump rule. There was a AMCOMP resolution passed on this as well because there's an issue with independent contractor status of insurance agents. There's been a number of few lawsuits dealing with the status of independent contractors as well, or if agents are ability to be determined to be an employee under wage and hour law protections. There's been some large lawsuits in those cases, and there is an AMCOMP basically came out and said, strict ABC tests or presumption of employee status applied to licensed professionals can be disruptive. I'll let anyone who wants to look that up look more into the specifics. But again, that's kind of a dual-edged sword when we're talking about independent contractor versus employee status. There's been some disruption in that area. I just brought up the number of states. There's probably more. This is not conclusive or comprehensive of states that have laws. This is from the WCRI IABC publication dealing with the workers' comp laws 2022, and really just the growth of mental across the country. And so I have some of the statuses there that folks can take a look at, some of the states in the materials. And it needs to be an extraordinarily mental stress from sudden stimulus. And then there's different states that pay different benefits in regards to those matters. And I'm running out of time, so I'm just going to move along here. I brought up single payer proposals. We hear a lot about that. Some of the states that have introduced those, most of those have failed under the weight of funding and other issues. There are some government public options where the state will compete with the insurer, but it appears that cost is a problem. And then this is just how is this going to affect workers' compensation? Is it going to get pulled in to single payer healthcare proposals? Should one pass? Should one state come up with the ability to fund such a plan? And keep our thoughts there regarding that. Another is PBMs, pharmacy benefit managers are regulated. And there's a growth of work at NAIC concerning regulation of them. And there are, of course, workers' compensation, pharmacy benefit manager issues. So take a look at that if you have some time. Climate-related workplace issues, mainly dealing with heat. Continue to consider these. They're going to be, states are moving more towards regulations and prescriptions concerning heat and extreme cold as well. And I mentioned some of the regulatory sandboxes that have gone across the state, some of the insurtechs and Some have been fintechs, financial and insurance based on Kentucky law. Doesn't appear to be a lot of uptake in these at this point. So the question is why? Is it too the process too restrictive? Does it need to be more restrictive? Where will sandboxes go? So we'll just continue to explore that possibly next time a little bit more in depth. So I'll stop there. Sorry I took up most of the time, but be happy to either try to answer any questions right now or at a later date. So thank you.
Yes, absolutely. Thank you, Andrew. And if you have any questions, feel free to shoot him an email there, apolly@namic.org, and we would love to get those addressed for you. Um, just to add a few things here at the end of the presentation, we have um, we have finalized the 2023 annual meeting. It'll take place on March 12th through the 15th in Charleston, South Carolina. Um, we do not currently have registration open, but it will open soon. So stay on the lookout for that. In addition to that meeting, we also have our final webinar of this series for the year in September. So be on the lookout for that and make sure to register on the website. And if you haven't already, follow our social media accounts. We would definitely appreciate a follow, and keep an eye out for important updates about the organization or any articles that we would post as well. But other than that, I think that's all we have for today. Thanks to everyone for your time, and thanks again, Andrew. Until next time, if you have any questions or anything, feel free to let us know. Thank you.